Hey everybody, so this is a quick gist of what I'm doing. I know I wrote it, but God, Facebook has so much to read. I know how it is. So petition for a writ of habeas corpus, and that means release one's body, and complaint for declaratory and injunctive relief with class action allegations. Now, I am not a lawyer, but I copied a lawyer. And this is the first time in history that the Department of Justice has admitted that separating children is wrong. They've ignored us for this long, and they do see the scope, is the best word, the scope of what we're dealing with. So things are being handled weirdly, I think, but once again, it's historical that they admitted to wrongdoing in separating parents and children. And I am copying the ACLU. Thank you guys. Because they basically wrote the case for us. And I am just ad-libbing us as parents, American parents, into the suit. So I'm going to read it real quick for you. The important parts. This case challenges the United States government's forcible separation of parents from their young children for no legitimate reason, and notwithstanding the threat of irreparable psychological damage that separation has been universally recognized to cause young children. And then Ms. T, this is Exhibit 1, parent, and members of this class bring this action to have the government reunite them with their young children, from whom they have been separated now for months and years. They also bring this action on behalf of the hundreds, if not thousands, of parents whom the government has forcibly separated from their children and continues to separate, without finding of parental unfitness and with no hearings of any kind. The government is seizing young children, leaving them with strangers, alone and frightened, often to other counties and states miles away from their parents. Oops. Forced separation from parents causes severe trauma to young children. The resulting cognitive and emotional damage can be permanent. Defendant Becerra, that is your Health and Human Services head, he's the guy in charge, he's even above Fauci, and Defendant Becerra's government actor Doe's. I'm sure there might be a better way to word that, but that's what I know from the last couple of years that I've been working on this stuff. So that's what they're getting called, and that would include everybody. They are government actors. Everybody below Becerra is a government actor, all those social workers. So have ample ways to keep plaintiffs together with their children. They give shelters to house immigrant families, including illegal immigrants, while they await the jurisdictional proceeding until final adjudication in juvenile dependency cases. If the government feels compelled to continue separation of these parents and children, it must minimally offer to detain them together, as they do for foreigners in family detention centers. And I'm sure, you know what, when it comes down to it, if they were to ever do something like that, which would be crazy, but if they did, I'm sure all of us would say okay, because we miss them that much. The due process clause, it's not going to happen, by the way, but I'm calling their bluff. The due process clause of the Fifth Amendment does not permit the government to forcibly take young children from their parents without exigency or even a hearing. Separation also violates the Administrative Procedure Act, which prohibits arbitrary government action. The judicial branch may no longer hold trust in the people if this court does not grant immediate preliminary injunction against the Department of Health and Human Services. And this is me. That all was the ACLU. Thank you again. This is me. Unconstitutionally delegated power to separate families. Congress cannot delegate a power they themselves do not have. Children, as even stated by law, are God-given. So to give a power to administrative branches to do that, it doesn't make sense legally. at the start. So we got Fifth Amendment, all the legal jargon. And then plaintiffs bring this action under Civil Procedure 23B2, and that's ACLU again. And I did pro se because that's what I am. And I don't know details about how it's going to work, but it will. Because, you know what, once again, it's historical that the Department of Justice admitted to wrongdoing. And this is just arguing to the point that we are adequate. The parents listed here are adequate representations to the proposed class. And more legal jargon. It violates blah, 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 procedural due process. Because I bet nobody's told you it is administrative law. It's not quasi-criminal and it's not civil. So we're working with laws that they don't even tell you we're working against. And that's in my argument too. That is in this part that I wrote. This is all me again. And this is fraud. Never do attorneys appointed by dependency courts reveal they speak to opposing counsel without informing their clients, the plaintiffs. They receive document service on parents' behalf, can and do hold secretive hearings without knowledge of parents. In every case before your honorable, these court-appointed attorneys do not say objections as asked to do so. Court-appointed attorneys do not submit evidence on plaintiff's behalf when asked to do so. Have ignored constitutional liberties to the extent of stating, and this is in my case, the Constitution does not apply here, and there is no time to argue the Constitution. Written, stated, sworn, and understood definition of, quote, representation is nothing of this sort, and is stated in the Dog Book, Dependency Handbook for Attorneys, stating their role is to make the process smoother for opposing party. They're not there to represent, but there to mitigate, in fact, a fact to which is never disclosed to distraught parents. These attorneys are forced to follow department lead, which is unstated and unwritten again at the department's will, and have court watchers to make sure of this as training states from the capacity building in DC. And that's some of the stuff you guys probably see in my group postings. Some of the things I've done behind the scenes is discover that. In other words, if an attorney attempts to properly represent the department, the department can and will remove them. So if you didn't know that. Knowledge of falsity. Parent plaintiffs are told by officers at the court that juvenile dependency is quasi-criminal or even civil in nature. Neither is fact. Juvenile dependency falls under administrative law, which is regulated by the APA and case law such as Chevron, which explains the deference given to agencies. A parent, when pro se or for mere understanding purposes, cannot make sense of what is happening to them in court because the laws they seek for reference that have been spoken as superseding the venue is civil or quasi-criminal. Attorneys in the courts do not disclose this as fact, tend to pick and pull statutes as they choose to benefit the agency and ignore the law of the land as we as Americans know, defend, and have sacrificed all to retain. Intent. Parents believe, and rightfully so, this is induced reliance. Parents believe, and rightfully so, they will never see their kids again if they do not comply with the agency demands despite and in spite of innocence. Court-appointed attorneys do not contact or communicate with parents until 10 minutes before the first hearing. This violates the service of paperwork rules of court. A court-appointed attorney in dependency hearings do not benefit if client wins or trial interaction is of short duration. Keeping the peace with their peers in juvenile courtroom rather than representing and presenting parents are of the most importance to them. This is made clear when all entities within the venue enjoy holiday parties and exchange gifts and even enjoy lunch breaks together. The appearance of impropriety exists. The fraud of action commences soon after. The fact is that all proceedings in juvenile dependency have pre-printed and pre-durational timeframes. This itself shows a factory-like process, not an individualized service for families as clearly stated in the Family First Act and all legislative intent acts established by Congress. Children are seized without exigency in nearly every case before your honorable, and finding of unfitness in court has not been established prior to removal, as judicial findings have established time again, after in which return of children becomes contingent upon a service that is only rendered if admission of guilt is made. This is the parallel definition of extortion, to release bondage of kidnapping, child being held until services rendered by parent. Yet, while even at the end of the completion of demanded services, for child to return, the agency retains discretion to actually return child to the parent. The calculation to determine this then becomes the time already stolen and best interest, in quotes. With interest in monetary accumulation, county prospectively can claim from child needs if kept in the system. Justifiable reliance. Child welfare, once contacted by them, causes a do-or-die situation for family. Plaintiff parents are told to do services or, in quotes, reunification, which is not reuniting with their children. It is a forced, open-ended contract made under duress. Children are seized without warrants, and return of them becomes the discretion of a social worker and not the imposed service completion. Servitude is required for release of children. Social services forces housing and drug services for parents never convicted of drug offenses. The time and duration of services is capricious and ambiguous. The child welfare system is capricious and ambiguous. All claims are vicariously the fault of Xavier Becerra as head of the Health and Human Services. Plaintiff alleges, and to the extent applicable, incorporates by reference herein as if set forth in full from the common allegations listed above, Xavier Becerra is vicariously responsible for the following claims. And then we go into fun stuff, due process violations, and there are more I need to add, I'm sure. And it's okay because this is what I'm going to throw at them. I might do intentional infliction because we all know that's what they do. But anyways, so what I want from parents, if possible, gosh, if they could do it themselves and send it to me, I'm okay with that. And I'll just edit if I need to. Hopefully I won't. 1 to 2 pages max of a rundown explanation to the court as an exhibit of what happened. So the facts in the case for Mrs. T is stated here, and they're all posted online if you want examples. Timeline is the best way I have found personally to get this together. It actually helped me see how things worked out in time, because everything gets so flustered and it's so confusing because they attack you from every angle. The timeline on the Excel spreadsheet helped me visualize it and make sense of it. So timeline of just incidences is Sacramento and then Solano for me. And so on. Examples are online. I am going to do additional things to add people because I understand not everybody has time, and you know, I know it's hard to go through this because every time we have to talk about it, we relive the trauma that they imposed on us. And this is true. And I don't expect to win, you guys. I don't expect to win a lawsuit against the best attorneys in the United States. But I do expect to win a settlement for us, and I expect them to return our children because that's the right thing to do. And really, they have no other option. Okay, I'm out.